Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. Before we begin, if you haven't already, please go ahead and hit that subscription button, turn that notification bell on, and hit that like button. I'll give you all a second to do that. All right, so this is basically going to be the second part of Do Not Talk to Police. So where we left off the last time was on this page right here. So I'm going to go down here. This video, it's not going to be too long. I'm going to try to keep it about 15 to 30 minutes. I'm going to try to keep it at 15 though. But anyway, I'm going to go ahead and jump right back into this. From these representative samples of interrogation techniques, the setting prescribed by the manuals and observed in practice becomes clear. In essence, it is this: to be alone with the subject is essential to prevent distraction and to deprive him of any outside support. The aura of confidence in his guilt undermines his will to resist. He merely confirms the preconceived story the police seek to have him describe. Patience and persistence, at times relentless questioning, are employed. To obtain a confession, the interrogator must patiently maneuver himself or his quarry into a position from which the desired objective may be attained. When normal procedures fail to produce the needed result, the police may resort to deceptive stratagems such as giving false legal advice. It is important to keep the subject off balance, for example, by trading on his insecurity about himself or his surroundings. The police then persuade, trick, or cajole him out of exercising his constitutional rights. Even without employing brutality, the third degree, or the specific stratagems described above, the very fact of custodial interrogation exacts a heavy toll on individual liberty and trades on the weaknesses of individuals. So there's a footnote. I'm going to read this footnote. Interrogation procedures may even give rise to a false confession, which we all know that. The most recent conspicuous example occurred in New York in 1964 when a Negro of limited intelligence confessed to 2 brutal murders and a rape which he had not committed. When this is discovered, the prosecutor was reported as saying, "Call it what you want, brainwashing, hypnosis, fright. They made him give an untrue confession. The only thing I don't believe is that Whitmore was beaten." Let me see. In 2 other instances, similar events had occurred, so they must be talking about this right here. I'm not going to read that. Well, I'm not going to go to what they're talking about. This fact may be illustrated simply by referring to 3 confession cases decided by this court in the term immediately preceding Escobedo. Our Escobedo decision. In Townsend versus Sane, 1963, the defendant was a 19-year-old heroin addict, described as a near mental defective. The defendant in, Lenham versus Illinois was a woman who confessed to the arresting officer after being importuned to cooperate in order to prevent her children from being taken by relief authorities. This court, as in those cases, reversed the conviction of a defendant in Haynes versus Washington in 1963, whose persistent request during his interrogation was to phone his wife or attorney. In other settings, these individuals might have exercised their constitutional rights. In the excommunicado, police-dominated atmosphere, they succumbed. In the cases before us today, given this background, we concern ourselves primarily with the interrogation atmosphere and the evils it can bring. In Miranda versus Arizona, the police arrested the defendant and took him to a special interrogation room where they had secured a confession. What is this? In Vignera versus New York, the defendant made oral admissions to the police after interrogation in the afternoon, and then he signed an inculpatory statement upon being questioned by an assistant district attorney later that same evening. In Westover versus United States, the defendant was handed over to the Federal Bureau of Investigations by, let me read this footnote. Let's see. In the fourth confession decided by the court in 1962, Fay versus Noah, our disposition made it unnecessary to delve at the length into the facts. The facts of the defendant's case there, however, paralleled those of his co-defendants, whose confessions were found to have resulted from continuous and coercive interrogation for 27 hours with denial of request for friends or an attorney. Let's see. Okay. This section I'm not going to read. I'm going to skip this section here. Y'all can go and read it if y'all want to. I just don't think it's really important. So I'm going to pause the video. Okay. We're still on the same page, but we just scrolled down just a little. So, I'm not sure why that's doing that. Oh, okay. Let's go down. Sorry about that, y'all. To be sure, the records do not evince overt physical coercion or patent psychological ploys. The fact remains that in none of these cases did the officers undertake to afford appropriate safeguards at the outset of the interrogation to ensure that the statements were truly the product of free choice. It is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. This atmosphere carries its own badge of intimidation, and they give a great example down at the bottom of this footnote 26. I'm going to read it too. To be sure, this is not a physical intimidation, but it is equally destructive of human dignity. The current practice of incommunicado interrogations is at odds with one of our. Let me go and read this footnote. This is the footnote right here. Suppose a well-to-do testatrix, what is that? I'm going to say testatrix, says she intends to will her property to Elizabeth. John and James want her to bequeath it to them instead. They capture the testatrix, put her in a carefully designed room, out of touch with everyone but themselves, and their convenient witnesses, keep them secluded there for hours while they make insistent demands, weary her with contradictions of her assertions that she wants to leave her money to Elizabeth, and finally induce her to execute the will in their favor. That's void. You can't do that. Assume that John and James are deeply and correctly convinced that Elizabeth is unworthy and will make base use of the property if she gets her hands on it, whereas John and James have the noblest and most righteous intentions. Would any judge of probate accept the will so procured as the voluntary act of the testatrix? And then there's another footnote right here. Well, I'm going to read that footnote later because it ties into what's going to be said up here. So let me go back up. Let me read this again, y'all. The current practice of this word gets me every time, y'all. Incommunicado interrogations is at odds with one of our nation's most cherished principles, that the individual may not be compelled to incriminate himself. Unless adequate protective devices are employed to dispel the compulsion inherent in custodial interrogations, no statement obtained from the defendant can truly be the product of his free choice. From the foregoing, we can readily perceive in an intimate connection between the privilege against self-incrimination and police custodial questioning. It is fitting to turn to history and precedent underlining the self-incrimination clause to determine its applicability in this situation. We sometimes forget how long it has taken to establish the privilege against self-incrimination, the sources from which it came, and the fervor with which it was defended. Its roots go back to ancient times. So let me go down here to that footnote 27 and read it. 13th century commentators found an analog to the privilege grounded in the Bible. Let me read that again. 13th century commentators found an analog to the privilege grounded in the Bible. To sum up the matter, the principle that no man is to be declared guilty on his own admission is a divine decree. What is that? This is like a Torah code of Jewish law. So this has something to do. It's a book of Judges, law of Sanhedrin, something like that. The Fifth Amendment and its equivalent in the Hakalah. So this is some type of Jewish law, code of Jewish law, civil Jewish law, something like that. So that's why it's very important to read cases, y'all, because these so-called judges, they do their research. They do their research pretty good, actually. Some of them do anyway. What is this? Perhaps the critical historical event shedding light on its origins and evolution was the trial of John LeBurn. Let's see, a vocal anti-Stuart leveler who was made to take the Star Chamber oath in 1637. The oath would have him bound him to answer to all questions posed to him on any subject. The trial of John LeBurn and John Wharton. Let me see. So this must be this must be some sort of real case. But anyway, he resisted the oath and declaimed the proceedings, stating, another fundamental right I then contended for was that no man's conscience ought to be racked by oaths imposed to answer to questions concerning himself in matters criminal, or pretended to be so. I don't know what they talking about with this Star Chamber oath. I'm not sure if y'all know what they talking about, if y'all old enough to know what they talking about, let me know. I don't know what they talking about. I'm thinking of some Star Wars type stuff or some Star Trek or something. But that's pretty good, though. The fact that this is that old, that's pretty good. Let's see how much time we got, y'all. Give me 1 second. Got to see how much time. We're at 13 seconds right now. So let me get back to the case. I'll stop probably after I read this paragraph right here. On account of the LeBrun trial, Parliament abolished the inquisitorial court of Star Chamber and went further in giving him generous reparation. The lofty principles to which LeBrun had appealed during his trial gained popular acceptance in England. These sentiments worked their way over to the colonies and were implanted after great struggle into the Bill of Rights. Those who framed our Constitution and the Bill of Rights were even aware of subtle encroachments on individual liberty. They knew that illegitimate and unconstitutional, unreasonable, unlawful practices get their first footing by silent approaches and silent deviations from legal modes of procedure. Interesting. The privilege was elevated to constitutional status and has always been as broad as the mischief against which it seeks to guard. We cannot depart from this noble heritage. Thus, we may view the historical development of the privilege as one which gropped for the proper scope of governmental power over the citizen. As a noble principle often transcends its origins, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. We don't have a democracy, we have a republic. But anyway, I wonder who wrote this opinion right there. Anyway, let me see. I think I'm gonna end the video right there because I'm trying to keep it at about 15 to 30 minutes. Because sometimes I make my videos too long. So I'm gonna end it right there. But I'm gonna do another video right after this one. It's gonna be part 3, and we're gonna continue from right here. So make sure y'all watch these videos, or at least go and read the case for yourself. As you can see, this case, what I'm seeing right here is about 110 pages. So you got to read, man, if you want to know this stuff. That'll be the end of this video. The Supreme Litigant is out. Peace.